Hello and welcome to American Friction, the supreme podcast with a liberal majority. I'm Jacob Jarvis. The Supreme Court isn't doing so well at the moment, and I want to dig into why that is. Our guest is Leah Litman, a professor of law at the University of Michigan Law School, co-host of the Strict Scrutiny podcast, and she's also the author of the new book, Lawless, How the Supreme Court Runs on Conservative Grievance, Fringe Theories and Bad Vibes. Leah, welcome back to American Friction.
Thanks so much for having me.
Leah, of late, how would you describe the way the Supreme Court has operated? And could you give me a rating out of 10?
Close to 1 or 2. Basically, the Supreme Court seems pretty aligned with the Republican Party's agenda. And so when I say the court is running on bad vibes, what I mean is they are taking their own feelings and the talking points of the Republican Party and the general zeitgeist of the Republican Party and laundering them through the law, or sometimes just declaring them to be the law. And I think that is really the trend in what the Supreme Court has been doing in a lot of high-profile cases.
Is that a shift that's happened there, where you point to not just pretending that the law is what gives their point of view credence, but suggesting that their opinion is just fact? Is that a bit of a shift in the tone of the way they're manipulating the law or abusing the law or ignoring the law? I don't know what way you'd sum it up.
Yeah, so I think the United States Supreme Court has always been political, but a few things have changed of late. One is the justices are now more likely to split along straight partisan lines in these high-profile cases, whereas before you had justices like Justice Kennedy, who sometimes voted with the Democratic appointees on issues of LGBT equality. You had justices like John Paul Stevens or David Souter, who also frequently voted with their Democratic colleagues. So the partisanship, the apparent partisanship of the court has definitely increased. And with that, I think that the extent of the court's lawlessness has moved to a different level. I'm happy to go into specific examples, but I just think the court's willingness to discount the law and make up the law has really gone to another level as the 6-3 Republican supermajority was consolidated.
Just with that, is some of that is it external forces which is making the members of the Supreme Court act differently with each other? Or is it an internal thing about the way they group? I always just find it quite strange that clearly very intelligent people are happy just to be put in their box when they're thrown on the Supreme Court and then just stick with it and never flip. So what's made that the case? Because it seems to me like, as you say, that you'd imagine that more often they would go, you know what, my brain is malleable. And now that seems to not be the case whatsoever.
So I don't know exactly how you would divide up internal and external. In my mind, it's probably a combination of both of them. So external factors, you have organizations like the Federalist Society or the Heritage Foundation engaging in basically nonstop programming that socializes the Republican justices in what it means to be a Republican. And that's a way of signaling to the justices what the Republican Party's views are. And that is, I think, an important mechanism that allows those groups to influence the direction of the court and potentially get the justices to change positions from what they held before. And then second is, I think there is an internal aspect to this in the sense that those same groups and others provide a very well-run and closed-off ecosystem that is constantly telling the justices, you are super principled, you are doing law when you use these methods like originalism or textualism to reach these preferred results. And so I think that feeds a sense of self among the justices, which I do think is important, where they perceive themselves to be independent, impartial judges, even though the reality is they are so often projecting the ideology of the party they are affiliated with. It just cannot be that simple.
With the court and the way it's changed, you said there's of late, and since it went to the 6-3 majority, there seems to have been a shift. But has there been a creep in the Supreme Court working less well, or was it just sudden? And if there has been a bit of a break, When was there last a period where it appeared the Supreme Court was working, at least not working badly?
So I do think there has been a slow creep. Before the 6-3 conservative supermajority, you still got some quite outlandish and, in my view, lawless opinions from the Roberts Court. One of my favorite/least favorite examples, depending on how you describe it, is Shelby County versus Holder, the 2013 opinion that invalidated a key provision of the Voting Rights Act that had required certain states with especially egregious histories of voter discrimination to pre-clear any changes to their voting laws with the federal government. And Chief Justice Roberts wrote the majority opinion that made that pre-clearance process unenforceable, based on this idea that there is a constitutional obligation for Congress to treat all states the same. So somehow in a case about voter discrimination, he made the former Confederate states, the states that were fighting on behalf of slavery in the Civil War, into the victims. And in order to say such a principle of equal sovereignty existed, he had to insert a misleading ellipsis into an earlier opinion that had said, actually, that doctrine just doesn't apply to laws that are enacted after a state is part of the United States. That's only a rule that constrains what Congress can do when it's admitting states to the Union. So I do think there has been a lawlessness creep that has really worsened over time. The recent immunity decision in particular illustrates the slop and gobbledygook that I think the 6-3 Republican supermajority now thinks they can get away with. As to whether there was a period where the Supreme Court functioned well, I would go back to what I said earlier as far as the Supreme Court has always been political and ideological in the sense that the justices' politics and ideology influenced what they were doing. But when the justices' views were more heterodox, that resulted in decisions that didn't neatly break down along partisan lines. And I think that gave a real appearance that the Supreme Court was doing something different than the other branches of government. If I had to identify, a moment where I think the Supreme Court kind of began jumping the shark, I would say the 2000 decision in Bush versus Gore, where 5 Republican justices anointed George Bush as president by halting the recount of votes in Florida and ordering Florida to certify Bush as the winner of the state's electoral votes and therefore the election.
With that, the power dynamic with the president, I'm not saying that either one of these should be the right way to go about it, because you'd hope they're making decisions based on the law and not based on these external factors. But to me, again, it seems strange that I would imagine if I was appointed to the Supreme Court, I'd be quite proud of the power that I wielded, and I would want to be treated as an equal branch of government and not be treated in a way that was subservient to the president. In the past, were they more likely to maybe push back against presidents to prove that point? And then is it now shifted that they've gone to being happily subservient? And has there ever been a point where they've really got that power dynamic quite right, that it should be a quite neutral power dynamic, really?
I think the Supreme Court has always been a little reticent to push back against the presidency because it is such a powerful institution. That being said, the court has pushed back against presidents, I think particularly in periods where those presidents' popularity has sunk to low levels, and especially low levels for them. So if you think about, for example, the Supreme Court's treatment of individuals who were detained at Guantanamo Bay, the Supreme Court basically prolonged the litigation over whether individuals who were detained at Guantanamo Bay had access to habeas corpus to challenge their detentions. And eventually, the Supreme Court said that they did, but because it had drawn out the litigation, it was in Bush's second term when, again, his popularity was significantly less than it had been earlier, and in particular earlier, in the War on Terror. As to what the Supreme Court is doing now, I think they think of themselves as checking the president, at least when the president is Democratic. Think about all of the cases where they ruled against the Biden administration, invalidating their efforts to cancel student debt or adopt a clean power plan to try to address climate change. So they can still conceive of themselves as checking the president. It's just they are way less inclined to do so when the office holder is a Republican.
Just with that, could you give me just a quick recap on the sort of split within the Supreme Court? And also, could you highlight maybe out of the 9, are there a couple who stand out as the strongest personalities and the people who are shifting the way the court behaves the most?
Sure. So there's a 6-3 right-wing supermajority on the court right now. Chief Justice Roberts, who was appointed by Bush II, is the chief. Justice Clarence Thomas was appointed by Bush I, Justice Alito by Bush II, and then there are the 3 Trump appointees, Neil Gorsuch, Brett Kavanaugh, and Amy Barrett. As to whether there are particular personalities, I think all of the justices have their quirks and particulars. I think Justices Thomas and Alito are in some ways the most MAGA, Make America Great Again forward justices, which I think underscores that the problem we are seeing right now at the Supreme Court is not just a Trump problem. It is a story about the deterioration of the Republican Party, given that it's, again, Bush II's appointee, Alito, and Bush I's appointee, Thomas, who are in some ways like most ideological, partisan, and right-wing. But again, all of the other justices kind of have their quirks and unique features. The 3 Democratic appointees who are in the majority include 2 of President Barack Obama's appointees, Justice Sonia Sotomayor and Elena Kagan. And then President Biden appointed Justice Ketanji Brown Jackson to the Supreme Court.
Just with the way that the Conservatives are behaving as well, I think there's a sense from a lot of Conservatives that they seem to act as though they are the downtrodden ones in society, even though they appear to be winning basically everywhere in the US at all times, it looks like to me. Are the Supreme Court Conservatives acting particularly hard line to represent that they are winning somewhere, and to maybe, are they acting like they're the voices of some sort of underdogs in a way?
Yes, absolutely. So this is why the subtitle of my book talks about conservative grievance and how that is what the Supreme Court is running on. Conservative grievance basically refers to this idea that it's the Republican right wing constituencies who are the victims of discrimination today and are unfairly targeted for their political beliefs or their religious ones. And I see that thread in all 5 of the different areas of law that I survey in the book, from reproductive freedom to LGBT equality to voting rights to the law on money in politics and political corruption to issues concerning the administrative state. In all of those areas, the Supreme Court has managed to make the group that's more affiliated with the Republican Party, whether that's the mega rich, the corporate executive, the white Southern conservative, or religious and social conservatives who are opposed to LGBT equality. It has made those groups into the victims who are more entitled and more in need of judicial protection. And the court has used that idea to strike down laws that try to make the country more equal and more inclusive in a lot of ways.
Won't we all just think more of the Christian billionaires? As we're talking about sort of conspiratorial thinking, then let's go to fringe theories now. What are some of the most infuriating, obscure theories that justices have used to justify their thinking of late?
Where to
start? That's a big question. Yeah, I'm sorry. There's
start?
A lot.
So I would pick one that is, I think, especially in the news and topical right now, and that's this unitary executive theory. That's the idea that the Constitution vests all of the executive power in the president alone, and that includes some powers that aren't even specifically or explicitly listed in the Constitution, which also requires the president to be able to control other individuals within the executive branch so he can ensure they are exercising executive power according to his whim. And that was a very fringe theory pushed by the Reagan administration, who sought to consolidate more power in the presidency. Early on, that theory would get at most one vote on the Supreme Court. And now it's getting 6. It was strong aspect of the immunity ruling when the Supreme Court said Congress could not regulate the president's powers over law enforcement, investigation, and prosecution. That reflects the unitary executive theory because it imagines the Constitution allows the president and the president alone to exercise some powers free of interference from other branches. And that was also this idea that led the Supreme Court to allow Donald Trump to fire the heads of these multi-member commissions, agencies, in violation of federal law. And so that is a fringe theory that has really taken on steam over the last 40 years and has enabled, I think, some of the more abusive exercises of executive power in the administration.
Just on one that I wanted to ask you about, which just stood out to me as quite a ridiculous theming bit of arguing that someone used, the Black Santa hypothetical. Uh-huh. Could you just talk me through a little bit about what that was all about? I suppose, on the surface, what it was about, but also why they're possibly trying to use arguments such as that.
Okay, so the Black Santa hypothetical came up in this case, 303 Creative versus Lawless. That case was a challenge to a state's anti-discrimination law, which prohibited businesses that serve the public from discriminating on the basis of sexual orientation. And the specific business at issue in 303 Creative was a wedding website designer or website designer. And the theory was it was unconstitutional and violated the First Amendment to require the wedding website designer who had religious objections to LGBT equality to make a wedding website that, celebrated same-sex weddings. And so during the oral argument, the Republican justices kept trying to identify these hypotheticals that tried to make her argument more sympathetic. And so the one that Justice Alito identified is he imagined a Black Santa who was being forced to take photographs with white children in KKK costumes. This is not remotely similar to the situation in 303 Creative, because the law at issue in 303 Creative prohibits discrimination on the basis of someone's identity, their status, their sexual orientation. Whereas a law that would prohibit a Black Santa from refusing to sit with white kids dressed in KKK costumes, that's about political beliefs, which have never been thought to override, other concerns or require the sort of protections that identity and sexual orientation or sex or race might.
I mean, I don't know what goes through your head to come up with that. But when you are coming up with things like that, though, and putting yourself in the head of one of these justices, are there ever times where fringe theories can be good? Have there ever been examples of people going for these sort of weird hypotheticals and it's useful? I think when you watch courtroom dramas and stuff, for example, and you're rooting for someone to be found innocent, there's always a lawyer who goes, "Oh, actually, here's the silver bullet I found." But it seems like maybe that works for individuals, but probably not for an entire society. Have there been times in the Supreme Court where a fringe theory has actually been quite positive to be pushed forward?
Yeah, so it probably depends what we mean by fringe theory. When I use the phrase fringe theory, I'm using it to describe theories that enjoy not majority support and are supported by a narrow segment of the country. And I also use it, I think, to describe theories that are, in a lot of ways, antagonistic or inconsistent with a liberal constitutional democracy. But of course, there are some fringe theories in the sense of unpopular theories, that people took to the Supreme Court that I think should have prevailed. So think about, for example, in the aftermath of Brown versus Board of Education, when the Supreme Court invalidated segregation in public schools, individuals then asked the Supreme Court to invalidate bans on interracial marriage, laws that prohibited white people from marrying Black people, etc. And at the time, a majority of the country, if not a supermajority of the country, supported bans on interracial marriage. So that theory, was perceived to be something of a fringe theory. And the Supreme Court decided to duck the issue and not decide it for over a decade after Brown versus Board of Education. So that's, a fringe theory in one sense, but I also think it reflects this idea that when you are dealing with groups that have been historically discriminated against, historically subordinated, and who face real alienation and unfair prejudice in the political process, in those circumstances, you can't just defer to majority views. You can't just defer to the political process. So that might be an example, but again, it kind of differs in some ways from other fringe theories, that I am focused on in the book.
With the way that the Supreme Court makes its decisions, I suppose sometimes you are dealing with laws which were written in a completely different time, society's moved on, and now you're having to assess the law, but also look at the way that society has changed as well, I guess. Would it be better for them to sometimes actually just be open about the fact that they're going off gut instinct, at least, if it does seem that they are just going based upon what their feelings are? Because there are some cases, I suppose, where the final choice they have to make is based on their gut instinct or is based on their own beliefs or what they believe the tone of the nation to be.
Yeah, so I do think it would be helpful if the justices were more transparent and acknowledge the extent to which some of the ways in which they reason draw on their ideas about what equality means or what liberty means and related political philosophies. That being said, I actually do think they are sometimes quite transparent about it in their writings. And part of what I do in the book is try to draw out examples from opinions where I think they've basically copped to that. So just to take an example, in the abortion context, when the Supreme Court overruled Roe versus Wade, one of the justifications that Justice Alito gave for why the Supreme Court was not bound to uphold Roe versus Wade is because abortion remained a controversial, divisive issue. So he is using people's feelings about abortion to establish what the relevant legal rules are respecting abortion.
Now, on a side note, let's talk corruption then. So how have the court's decisions on corruption changed federal law to permit influence peddling that I think most Americans would be quite annoyed by? And is there a bit of a feedback loop here that the laws they're changing are allowing them to be more influenced in the ways that you mentioned earlier as well?
Yes, I think so. And I think the two areas of law where that's most apparent are the law of campaign finance and then the law on political corruption. That is what counts as political corruption. So in the campaign finance space, the Supreme Court has dismantled laws that prohibited corporations and political action committees from spending unlimited amounts of money in politics. They've also dismantled laws that establish limits on the total amount of money that the mega rich could give to different candidates and committees. And all of that has allowed the mega rich to purchase access to political officials. We saw that in the 2024 presidential election when you had the richest man in the world pour in more than $200 million into the cause of electing Donald Trump and got himself access to the powers of the presidency in doing so. And then the second strand of cases are less known, but those are instances where the Supreme Court has interpreted federal laws that prohibit corruption. And the court has so narrowed those laws, it has said, look, the only real kind of corruption is quid pro quo corruption, where there's an explicit agreement. So a mega rich person gives a politician $100,000 and the politician says, okay, in exchange for this, I will vote for this bill. But of course, the mega rich can purchase themselves influence and access, and that too reeks of corruption. But the Supreme Court has said, no, that's just how politics work. And I think you can draw a straight line from those decisions to the justices' own behaviors, where they have allowed the mega rich to buy them trips, buy them gifts, and coddle them and swaddle them in this media ecosystem that reaffirms them and validates them for reaching the results that the mega rich and Republican Party would like them to reach.
just around this McDonnell versus United States. That seems to be a particularly infuriating case. Can you just talk me through that a little bit?
Yeah, so that's a case where the former governor of Virginia and his wife were indicted and convicted for violating federal anti-corruption law for accepting gifts in exchange for performing official duties. The specifics of the case were so extreme. They involved the CEO of a corporation giving the former governor and his wife, tens of thousands of dollars in loans, gifts for their daughter's wedding, Rolexes, dresses, and whatnot. And in exchange for that, the governor plugged the product of the CEO's corporation. He arranged meetings for the CEO. He held events, at which he discussed this corporation product. It was like a nutritional supplement. And he said, I use it, it's great. And he encouraged other state officials to do so. And the Supreme Court said that wasn't corruption because there wasn't a specific official action with the power of law, like adopting some regulation that had been done in exchange for the gifts. And instead, they literally described those facts as the way our government works. They said, look, that just reflects the basic compact underlying our system of representative government, where elected officials hear from their constituents. That is not how representative government is supposed to work, to be able to buy access to a political official. And I think that framing was very telling.
Does the Supreme Court sometimes just decide to kind of shrug when a ruling looks difficult like that? Because that does feel to me like they've just gone, yeah, it's kind of a mess. What are we going to do about it?
Yeah, so I think there are basically two ways, maybe even three ways that the Supreme Court does that. One is the Supreme Court has near plenary authority to decide which cases it even takes, which cases to set for oral argument and decide. So if it looks at a case and thinks, oh my gosh, we don't know what to do here, it might not take the case to begin with. Second is even after it takes a case, it can do what's called dismissing a case as improvidently granted, which just says, look, we made a mistake in trying to hear oral argument and resolve this case, so we're not going to issue a decision. We're just going to leave in place the lower court ruling. And then the third option is they basically try to find another less complicated way of resolving the case rather than weighing in on the tricky issue. So yeah, they have lots of squirrely ways and different ways of avoiding questions that they don't particularly want to or feel equipped to answer at any particular moment.
Just with the key issues for the Supreme Court then at the moment, and I want to ask you this question in two ways, I suppose. So what are the key issues of law that they kind of need to be ruling on at the moment? And that's grounded in reality, first up. But then, secondly, what are their pet key issues that they're going to wade in on that may be are pretty pointless for everyone for them to get too involved in?
Yeah, so I think that the issues they have to weigh in on are basically teed up by a lot of what the Trump administration is doing. So in particular, summarily expelling people to a foreign mega prison on the basis of a law that clearly doesn't apply and without due process. A lot for the Supreme Court to say that they should say in that case and related ones. There are other, I think, outlandish Trump policies that should be invalidated by the Supreme Court. It's a little tough to describe this question because on one hand, they have to weigh in on these issues. On the other hand, I know when they do, it's just going to make the situation worse and they're going to do the wrong thing. So, trying to balance those considerations in my mind. As to the pet issues, these guys love to attack LGBT equality. They're going to take up the question of whether bans on conversion therapy are constitutional. They're going to take up other cases that allow them to continue to claw back LGBT civil rights. My guess is they are going to continue to attack campaign finance law. There still remains some parts of campaign finance law standing. They're going to continue to whittle away at what remains. And then I think there are other issues that they are interested in, such as presidential power, that they are definitely going to issue more decisions about consolidating Donald Trump's power over administrative agencies and officials within the executive branch.
So I guess the key hope is just that they hopefully work slowly, at least, because it sounds like everything they're going to do is going to be bad.
Yes. Not something they want to do, unfortunately, but yes, that's a hope.
Leah, thanks so much for joining me today and talking me through all that.
Thanks for having me.
And thanks to all of you for joining us for American Friction. Do make sure you check out Leah's new book, Lawless, How the Supreme Court Runs on Conservative Grievance, Fringe Theories and Bad Vibes. There's a link in the show notes. And if you enjoy what we do, remember you can support us on Patreon. Go to patreon.com/American Friction. There's a link in the show notes. I'm Jacob Jarvis. Thank you for listening to American Friction.